In the summer of 2025, headlines again roared with news that brought immigration policy to the center of national discourse. The U.S. Immigration and Customs Enforcement, ICE, under the Trump administration, had issued new directives fundamentally altering the rules around who qualifies for release from immigration detention. Specifically, many non-citizens, including long-term undocumented immigrants, would now be categorically denied the right to a bond hearing before an immigration judge. This change, rooted in a reinterpretation of a decades-old statute, escalates the administration's aggressive crackdown on undocumented immigration. The announcement signals not only a significant departure from long-standing legal norms, but also ignites fierce debates over civil liberties, humanitarian obligations, and the proper bounds of executive power in immigration enforcement. This article examines the origins, implementation, and consequences of this sweeping policy change. It dissects the legal maneuvering involved, the political motivations underpinning it, and the real-world impact on detainees, communities, and the American immigration court system. As we navigate the growing complexities of modern immigration enforcement, this development stands as a powerful reminder of how administrative interpretation of law, not just new legislation, can redefine the lived reality for hundreds of thousands of people. The legal foundation, reinterpreting a 1990s statute, the statute in question, INA Section 235, the Immigration and Nationality Act, INA, a massive framework governing immigration law in the United States, was overhauled in the 1990s primarily through the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, IIRIR. Among its many provisions, Section 235 stipulated that any non-citizen arriving at a port of entry or crossing into the country unlawfully shall be detained pending proceedings. Until recently, however, that directive was not interpreted literally in all cases. For decades, ICE granted many non-citizens bond hearings, especially for those who had been living in the country for years without legal status, but who had no significant criminal record and posed no flight risk. What changed under the Trump administration was the legal interpretation of Section 235. Instead of viewing detention as conditional and subject to judicial discretion, the Department of Homeland Security, DHS, working in conjunction with the Department of Justice, DOJ, decided to reinterpret this section as mandating detention for all unauthorized entrants regardless of how long they had been in the country. What is a bond hearing and why it matters? A bond hearing is the legal process by which an immigration judge determines whether a detainee can be released from custody while awaiting immigration court proceedings. During these hearings, detainees have the opportunity to demonstrate that they are not a flight risk or a danger to the community, a right central to the principles of due process. Removing the availability of bond hearings strips immigration judges of their traditional role as checks on executive authority. Instead, under the new policy, the decision to release rests solely with ICE officials, a dynamic that many civil liberties groups argue leads to unchecked detention power, potential abuses, and widespread human suffering. DHS, memo, and legal repositioning. According to sources familiar with the memo outlining the change, DHS made this reinterpretation as part of a strategic legal recalibration. The memo states that all non-citizens who entered without formal admission, whether at ports of entry or between them, are to be detained without the opportunity for bond. This maneuver is possible due to the significant legal ambiguity in immigration law, which gives executive agencies broad leeway in interpretation. Legal scholars point out that while the INA says such individuals shall be detained, the Constitution still demands due process. That tension is now likely to become a battleground in federal courts. Expansion of executive power and the politics behind the policy. Trump's immigration legacy. Zero tolerance revisited. From the moment Donald Trump launched his first presidential campaign in 2015, immigration enforcement was a cornerstone of his political platform. Now, during his second term, the administration's approach has evolved into what analysts are calling the most expansive use of executive authority in immigration detention in modern U.S. history. By reinterpreting the statutory language of the Immigration and Nationality Act, the Trump administration has effectively nullified the discretionary power of immigration judges, a hallmark of a fair legal process, and redirected it to enforcement agencies. This shift embodies the administration's belief in a detain first, ask later philosophy. The role of the One Big Beautiful Bill Act, signed into law by President Trump on the 3rd of July, 2025, the One Big Beautiful Bill Act dramatically altered the financial and operational landscape for immigration enforcement. Among other provisions, the legislation allocated $75 billion directly to Immigration and Customs Enforcement, ICE, and included funding to expand detention capacity to over 100,000 individuals at any given time. This monumental investment also permitted the hiring of 10,000 new deportation officers, nearly doubling ICE's personnel. It solidified the institutional infrastructure necessary for mass, prolonged detention without bond hearings. Tricia McLaughlin, spokesperson for the Department of Homeland Security, DHS, emphasized the administration's goals in a statement to the press. President Trump and Secretary Noem are now enforcing this law as it was actually written to keep America safe. And now, thanks to the Big Beautiful Bill, we will have plenty of bed space to do so. No, a shift in narrative. From due process to public safety. The administration has framed the policy change not as a legal reinterpretation, but as a return to faithful enforcement of existing law. By declaring that those who were not formally admitted shall be detained, ICE officials argue they are merely restoring the original legislative intent behind INA Section 235. However, critics point out that this argument ignores over 2 decades of judicial precedent and agency practice, where discretion was exercised to balance public safety with due process. They argue that the new policy prioritizes political optics appearing tough on immigration over constitutional fairness. Greg Chen, the head of government relations at the American Immigration Lawyers Association, ILA, stated, "This automatic detention rule means hundreds of thousands of people will be deprived of their liberty even if there's no need for them to be detained. Legal, humanitarian, and constitutional challenges." Due process under fire. Central to the U.S. Constitution is the principle that the government cannot deprive individuals of life, liberty, or property without due process of law. Legal experts argue that blanket denial of bond hearings violates this bedrock principle, especially for individuals who have lived and worked in the country for years and have established community ties. The ACLU and immigrant rights organizations are preparing legal challenges that argue the policy shift violates the Fifth Amendment's Due Process Clause. While immigration law does not afford the same protections as criminal law, courts have consistently ruled that non-citizens are still entitled to a modicum of due process. Judicial pushback expected. In the wake of this policy change, immigration courts across the country are bracing for a flood of cases and challenges. Already, in places like California, New York, and Texas, immigration judges report confusion and resistance over how to interpret ICE's new legal position. Some judges have questioned whether ICE even has the authority to strip them of the discretion to grant bond. Others worry that the sudden reversal will contribute to overcrowding and delays, overwhelming a court system that is already severely backlogged with over 3 million active immigration cases as of July 2025. the psychological toll on detainees. Beyond legalities and political rhetoric, the human impact of indefinite detention without bond is profound. Detainees, many of whom are not accused of any crime, now face the prospect of months or even years behind bars without the opportunity to make a case for release. Mental health professionals warn that prolonged detention can lead to depression, anxiety, PTSD, and suicidal ideation. These risks are especially acute for asylum seekers, victims of trafficking, and individuals fleeing violence. Numerous case studies are already emerging, including that of Rosa Martinez, a Honduran mother of two who has lived in Arizona since 2009. Despite having no criminal record, her application for bond was denied under the new rules. She now remains detained at the Eloy Detention Center while her 11-year-old son is left in foster care. The historical context: comparing past immigration detention policies. The evolution of detention, from civil enforcement to mass incarceration. To understand the magnitude of the Trump administration's recent policy shift, one must examine the evolution of immigration detention in the United States. Historically, immigration detention was viewed as an administrative, civil process, not punitive incarceration. Detention was used sparingly, primarily for those deemed a flight risk or public danger. However, this began to change significantly in the 1980s and 1990s. The Anti-Terrorism and Effective Death Penalty Act, 1996, and the Illegal Immigration Reform and Immigrant Responsibility Act, IIRIRA, 1996, introduced mandatory detention for certain categories of non-citizens, especially those with criminal records. These laws greatly expanded the detention authority of the federal government, laying the groundwork for the enforcement-heavy landscape we see today. What makes the current shift under Trump so dramatic is that it takes a law originally crafted to target specific, high-risk individuals and expands its scope to include virtually all undocumented migrants, regardless of context or danger level. Precedents in discretionary relief. Even during previous Republican administrations, such as those of George W. Bush or Ronald Reagan, immigration authorities retained a measure of discretion. Immigration judges were able to consider an immigrant's ties to the community, history of employment, or potential asylum claims when deciding on bond. The concept of individualized review has long been a fundamental part of U.S. legal philosophy. The Obama administration, while overseeing a record number of deportations early in its tenure, still respected this principle by prioritizing certain groups, e.g., recent arrivals or serious felons, while granting relief or bond opportunities to others. Thus, the Trump administration's reinterpretation appears to not only be a policy change, but a repudiation of decades of bipartisan precedent and established immigration norms. Operation Wetback and historical parallels. Some observers have drawn comparisons between the current policy and Operation Wetback, a 1950s-era deportation campaign. That operation, conducted under the Eisenhower administration, resulted in the removal, often forced and chaotic, of hundreds of thousands of Mexican nationals and U.S. citizens of Mexican descent. While not identical in design, both the new ICE detention policy and Operation Wetback reflect a broader government willingness to sacrifice due process in the name of swift immigration enforcement. In both cases, the executive branch invoked national security, economic protectionism, and restoring law and order to justify massive detentions. Notably, Operation Wetback is now viewed by historians as a shameful chapter in U.S. immigration history, criticized for its brutality, racial profiling, and legal overreach. Whether today's actions will be viewed similarly in hindsight is an open question, but the echoes of the past are unmistakable. Political reactions and the 2025 election climate, Republican endorsements, and strategic framing Within conservative political circles, the new ICE directive has been widely praised. Republican lawmakers, particularly those aligned with President Trump and Secretary of Homeland Security Kristi Noem, have framed the policy as a necessary response to a border invasion and an overdue correction to what they call activist immigration judges undermining U.S. sovereignty. Senator Tom Cotton, RAR, a close Trump ally, declared during a press conference, "We've finally restored common sense to our immigration laws. Illegal immigrants should not get the same protections as law-abiding citizens." The administration's communications have consistently emphasized the policy as a return to the original intent of Congress, not as a new rule, but a correction of decades of bureaucratic leniency. Democratic opposition and human rights concerns. Meanwhile, Democratic leaders and civil rights organizations have responded with outrage. Speaker of the House Hakeem Jeffries issued a statement calling the policy a direct assault on the fundamental rights of due process and human dignity. Human rights watchdogs, including Amnesty International and Human Rights First, have condemned the measure as arbitrary and inhumane. In a joint letter, more than 100 organizations accused the administration of weaponizing immigration detention to suppress communities of color and immigrants. They also highlighted that many of those affected by the new policy are longtime residents, individuals with U.S.-born children, deep roots in their communities, and pending asylum claims. To strip them of a chance to argue their case before a judge, they argue, is to deny them basic justice. The 2025 electoral calculus. The new ICE detention policy comes at a politically strategic moment. As President Trump seeks to solidify support ahead of the 2026 midterms, immigration once again serves as a rallying cry for his base. The administration is betting that strong immigration enforcement will galvanize rural, suburban, and working-class voters concerned about border security, economic competition, and cultural change. Polling conducted by Gallup in July 2025 reveals a divided nation. 42% of Americans support the new policy, 48% oppose it, and 10% remain undecided. Support is highest among Republicans, 81%, and lowest among Democrats, 19%. Independents are split, with 47% opposing the policy. As with many Trump-era immigration initiatives, the bond elimination policy is not just a matter of governance, it's also a political message.